I'm Barry Marks with Marks & Associates, and I'd like to share with you some of what I've learned over the years representing banks, equipment lenders, and equipment leasing companies. What about state licensing and usury laws? For many years, leasing companies did not pay a lot of attention to state law. That is changing in part due to the application of Dodd-Frank, the federal act that applies to bank leasing subsidiaries. That law makes it clear, and it probably always has been the case, that state laws do apply to equipment finance agreements, whether they're EFAs, equipment leases, or leases intended as security. California is the only state that has a broad-based lender licensing requirement. The other states, however, may have licenses required, particularly if the lessor is in the business of micro-ticket leasing, something under about $25,000, or leasing motor vehicles, which require, in many cases, compliance with the motor vehicle registration laws. These can be frustrating and often are ignored, too often. The penalties for failure to pay attention to licensing laws can be severe and even criminal. What about usury? Again, most lessors don't pay a lot of attention to usury because they're doing equipment leasing. The leases don't include the word interest anywhere, and there is a lot of precedent in the case of true leases that usury should not apply. Usury is the limitation on the amount of interest a lender can charge. In the case of an EFA, there is interest involved, although it may be argued that if the transaction is structured so that the interest is imputed in the payment, it should not be subject to usury. That is a dangerous position, quite frankly. What about leases intended as security, buck-out leases? Those leases are very likely to be subject to state usury laws, although there is a contrary argument. We're not about to answer that question at this point, but we will say this. Leases that involve imputed interest rates in excess of about 18%, leases that involve very small amounts financed, such as leases of under $25,000, leases that have a dollar purchase option or are structured as equipment finance agreements should all contain some form of protection for the lessor lender. One is choice of law, stating that the law of a favorable jurisdiction to which the transaction has a substantial connection will apply. That usually means the law of your jurisdiction. Two, to support a choice of law clause, it is very often a good idea to have a consent to jurisdiction. The judge in your state is more likely to apply the laws of your state than the judge in the lessee's state. And three, we recommend the inclusion of a usury savings clause, a statement that if, despite the intention of the parties, the transaction is considered to be a lending transaction rather than a lease, if the judge goes that far and determines that the rent includes interest, then the interest will be reduced to the maximum amount permitted by applicable law. None of these things are bulletproof. And this video should not be considered a statement of the law across the board, so much as suggestions. For further information, please visit our website, www.leaselawyer.com.